USCIS just issued an important policy alert clarifying that a grant of U non-immigrant status is not considered an admission for purpose of adjustment of status under INA 245 subsection A. I am Muhammad Amir. I'm an immigration attorney and founder of Amir Law Firm. In this video, I will explain what this policy means, how it affects U visa holders, and what pathway remains available for U visa holders seeking permanent residency. Before I start, make sure to subscribe to our channel and turn on notifications so you don't miss our new videos and updates. On November 2nd, 2025, USCIS updated Volume 7 of its policy manual to align with the Supreme Court's decision in Sanchez, which says Mayorkas, that the Supreme Court clarified that obtaining a non-immigrant status inside the U.S., such as U status or temporary protected status or TPS, does not count as being admitted to the country under immigration law. That means that U status holder who received status while already inside the US cannot rely on the status as an admission for purposes of adjustment under INA 245A. Let's unpack this. Under INA 245A, to adjust status to lawful permanent residence, a person must have been inspected and admitted or paroled into the US. A U visa, however, can be granted without leaving the country. It confers a non-immigrant status but not an admission. The Supreme Court called this the daylight between non-immigrant status and admission. So while a U visa offers a legal status and work authorization, it does not count as an admission at a port of entry, thus cannot support adjustment of status under INA Section 245A. USCIS acknowledged that in the past adjudication may have been inconsistent because there was no clear policy guidance. Some U visa holder applicants may have filed adjustment under 245A by mistake. Now USCIS will apply this interpretation prospectively, meaning it affects applications adjudicated on or after November 2nd, 2025. Cases already decided or filed before that date should not be reopened unless the USCIS determines otherwise. USCIS cited both Sanchez and Loper Bright Enterprise, emphasizing that the agency must interpret the statute based on the plain language, not administrative discretion. So if U visa holder who received U status while already in the US cannot rely on the status as an admission and can't apply for adjustment under the INA 245A, is there any other path available for such U visa holders to apply for adjustment of status and obtain green card? Answer is yes. Congress deliberately drafted 245M1 to cover two groups of U non-immigrants. Number one, those admitted into the US on a U visa at a port of entry after counsel processing. And number two, those who were already in the US and otherwise provided non-immigrant status by USCIS. The second phrase, the otherwise provided non-immigrant status, is what distinguishes 245M from 245A. Under 245A, adjustment requires a lawful admission or parole. Under 245M, the person need not have been admitted as long as they were granted U status, which is otherwise providing non-immigrant status. So in effect, 245M covers those who were never formally admitted but later granted U status. That's what the Supreme Court in Sanchez recognized and what the USCIS now codified in policy. While 245M does not waive admission, it creates an alternative statutory basis that satisfies Congress' intent for U visa holders. In short, the grant of U status is not equal to lawful entry or admission, so the agency is aligning its policy with the Supreme Court's clear wording. In summary, a U visa grant inside the US is not an admission under I-9A 245A. U visa holders remain possible under 245M. This guidance took effect November 2nd, 2025, and the USCIS is accepting feedback until December 3rd, 2025. So subscribe for more immigration law updates and practical analysis. Thank you for watching, and I will see you in our next video.